Hello, everyone. It's been quite a while, hasn't it? I've had a few messages actually, even being kindly asking if I'm okay because it's been such a while since I've done any videos. Um, Thank you so much to the lovely people who cared. I'm fine. I took some time away because there is literally nothing happening on any of the dockets that I'm watching. So I've got a few things I want to go over. I will be going back over with my thoughts about Celeste Smith and her complaint against Wayfarer and Steve Sarrett. I'll also be going over some of the unsealed documents as well, just a couple of bits which I've had some thoughts of, or someone else has spoken about. So now I want to kind of give my take on what they were talking about. But right now, I've got about 3 videos I have to get to first, which are going to cover this case, the estate of Travis Flores against Brian Freedman. And where we left it last was Freedman had requested that the judge be replaced, and that has happened. He had filed a motion to strike and anti-SLAPP. So now we're going to start with the opposition from Clement Ciori, who is the widow of Travis Flores. And I've got this video is going to be the opposition. Then I have in the next video I'll have a declaration from Clement Ciori and someone else, Melissa Yeager. I'm sure we will find out who that is. And then after that, I will get to the response from Freedman and his firm, the reply brief to the opposition. And I know that there was a hearing on the 5th of March. We don't know yet the outcome of that. It was to decide on the motion to strike. So the outcome of that was that the judge is going to take it under advisement. So there's no decision yet. But as soon as I know, I will let you all know. So yeah, we have a few videos which are going to be about the estate of Travis Flores, Brian Freedman case, which I find this case absolutely fascinating. Sometimes it's kind of nice to get away from Lively or the Jones work side of things. And I do think this is kind of, I don't know, I don't want to say related. It kind of is. It kind of is in that it's not. So obviously part of the allegations from Clement Ciori is that basically Brian Freedman ditched and failed Travis Flores, so he could represent Justin Baldoni, a more lucrative client. Like Brian Freedman does not have his pick of lucrative clients, but also the cases are years apart. So it's not like it's not like Brian Freedman could have foresaw that he was going to end up representing Justin Baldoni years later in a completely unrelated case. So I personally, my opinion of the complaint against Freedman is that it's ridiculous. However, we are going to go through it. It's quite interesting because the Travis Flores case it's been something I've covered anyway from the start of covering the Lively case. I've done the deep dives into it. I've gone over the case quite a few times. I've often batted away pro-Lively people who made stupid comments such as oh well, Justin Baldoni was once sued by a dead man. They've been really distasteful, not my words. But I've had to we've had that right from the start, and there's always been someone who's been trying to link these two together, and now out of the woodwork suddenly Travis Flores' widow is now suing Brian Freedman, and the complaint makes no real sense. And I feel very much like Celeste Smith, it's like, oh, this is timing. This is interesting. Um, yeah, so we'll go through this, and we'll just see, where it kind of goes. Okay. Okay, so and the caveat, as always, is I am not great at pronouncing French names, so I do say Clemenziori. I don't know how close I am, but I feel like it's at least something, it's identifiable as a potential name. But I am not. If anyone's heard me, following the Macron lawsuit, you'll all appreciate that my attempt to pronounce anything in French is just not good. Okay, so plaintiff Clemenziori, individually and as administrator of the estate of Travis Michael Flores, submits this opposition to defendant's special motion to strike plaintiff's complaint. Okay, so the introduction. Defendant's attempt to repackage this lawsuit as an attack on speech and petitioning. It is not. Plaintiff's causes of action arise from defendant's attorney misconduct, malpractice, breach of fiduciary duty, and breach of contract, grounded in the duties of competence, loyalty, and confidentiality owed to Travis Flores, now represented by his estate. The gravamen is defendant's disloyal, negligent, and conflict-tainted conduct in and after the representation, not the exercise of free speech rights. To the extent defendants point to public-facing communications, those allegations merely provide context or evidence of disloyal conduct. They are not the basis on which plaintiff seeks relief. The anti-SLAPP statute targets claims based on protected activity, not professional duty. Claims that only incidentally reference communication while seeking relief for non-protected misconduct. The core of plaintiff's complaint concerns defendants 1. Inadequate pre-filing investigation, 2. Abandonment of Travis Flores' case shortly after filing, 3. Advising Travis to sign a settlement that provided no compensation, and 4. Failure to maintain and deliver a complete client file. None of these allegations arise from protected activity under the Anti-SLAPP statute. Plaintiff does not seek to silence defendants or restrict their general ability to defend Justin Baldoni even in the press. Plaintiff seeks to enforce the narrow but vital rule that a former attorney may not discuss his client and leverage a prior representation. Just really quickly there to interject, what happened there was it was quite simple. Predictably, the news had caught wind of this case. The fact that Brian Freedman represented Travis Flores in opposition. So Travis Flores obviously sued Wayfarer and Justin Baldoni amongst many other people and entities. And Brian Freedman was representing Travis Flores. He now represents Justin Baldoni. But, they caught wind of the fact that Freedman once represented someone who was suing Justin Baldoni. So effectively, batting for the other side. And they asked him about it. And all he said was, quite simply, was that the case was settled. There was no admission of liability. Something quite factual and very much publicly available information. I could look on the previous case, as I have done, and I can see that the case was dismissed voluntarily by Travis Flores. There was no admission of liability. So, this is what bothers me is, there is nothing wrong with Freedman saying that. And I don't know why this guy has got a bug up his ass about it. But anyway, we continue. Okay. Um, Plaintiff seeks to enforce the narrow but vital rule that a former attorney may not discuss his client and leverage prior representation. Defendants' framing of their argument ignores a bedrock principle: an attorney's speech rights are not identical to a non-lawyer's when the speech trades on a client relationship. A lawyer's right to freedom of expression is modified by the lawyer's duties to client, and the duty not to misuse client confidential information applies to discussion of public issues. And again, just to remind everyone, there was no confidential information that was shared. What was shared was very much publicly available. California's anti-SLAPP statute is not a safe harbor for malpractice and fiduciary breaches. Courts recognize the governing principle that a client's malpractice fiduciary duty suit against former counsel is generally not subject to California Civil Procedure, Section 425.16. Okay, so the background facts. Travis Flores retained attorney Brian Freedman and his company in July 2021 to pursue claims arising from alleged misappropriation of his October 26, 2025 copyrighted screenplay entitled 3 Feet Distance and related idea submission dispute. So that was captioned Flores versus Baldoni et al. Defendants undertook representation that included filing litigation in federal court and prosecuting the matter through March 2022. Defendants' efforts consisted of little more than filing a complaint and then quickly settling the copyright action. Defendants undertook no investigation and no discovery. Defendants advised Travis to resolve the matter through a settlement with no recovery to him. Travis passed away on May 23rd, 2024 at the age of 33. Defendant Freedman later began representing Justin Baldoni, Travis's former litigation adversary, in an unrelated, high-profile litigation against Blake Lively and her husband, Ryan Reynolds. The complaint alleges attorney Freedman began openly discussing Travis's confidential attorney-client communications and his low opinion of the merits of the copyright action that Freedman had filed to Baldoni, the media, and the general public. I'll be curious to know how this guy is aware that Freedman discussed anything to Justin Baldoni about Travis Flores, anything confidential. So obviously Justin Baldoni was the other party in the case, so there will be some information he will already be aware of. He will know how the case settled. And this is the stupidity of this complaint. In January 2025, the complaint alleges that following press inquiries about this unusual circumstance. What? In January 2025, the complaint alleges that following press inquiries about this unusual circumstance, and then there's a full stop, seems to just stop abruptly then. I think it was supposed to, yeah, it's going to start a new sentence where I think that should have been a comment or comma. Okay. Rather than simply answer no comment, Freedman issued public statements about the prior dispute and asserted lack of merit and the absence of liability for Baldoni and his company. For example, in a US Weekly article published on January 23rd, 2025, which is attached as Exhibit A, Attorney Freedman is quoted in relevant part as follows. This is really badly put together with the spelling typos and the grammar. It really bothers me and it feels jarring to read this. Okay, let's read this US Weekly article. In the copyright infringement case, I learned what great people Justin and Wayfarer were. I learned that they did absolutely nothing wrong and that there was no liability on their part whatsoever. As a result, The case was resolved without any liability on Justin's or Wayfarer or any other defendant's part. This only further confirmed to me that Justin and Wayfarer are exceedingly honourable and highly ethical. Okay, I'm really struggling to see the confidential information that belongs to Travis Flores that is in that quote. There's no confidential information there. In the wake of the defendant's statement to the media, plaintiff and two families were thrown into the media storm. After Travis's death, plaintiff, as surviving spouse and court-appointed administrator of the estate, requested the complete client file and related materials necessary to administer the estate and evaluate claims. Plaintiff contends defendants failed to provide a complete, unaltered client file and failed to preserve and/or return categories of client materials, including, among other things, invoices, drafts, texts, emails, internal notes, and work product. These facts support claims for breach of contract, breach of fiduciary duty, and malpractice based on non-speech professional misconduct, competence, diligence, loyalty, confidentiality, and file return obligations that continue after a client's death. Okay. A special motion to strike is evaluated in two steps. 1. The moving defendant must show the challenged claim arises from protected activity. And 2. If that showing is made, the burden shifts to plaintiff to show a probability of prevailing. The courts consistently hold that a claim is not subject to anti-SLAPP simply because protected speech is mentioned in the complaint or occurred in the background. While communications made by individuals participating in official proceedings may be protected activity, a claim is only subject to the anti-SLAPP statute if the speech itself is the wrong complained of. Defendant's motion fails at prong 1 because defendant's claims for breach of contract, breach of fiduciary duty, and malpractice are based on non-communicative attorney misconduct, conflicts, disloyalty, confidentiality breaches, and failure to return a complete client file, rather than any protected petitioning or speech. Even if the court reaches prong 2, plaintiffs can show minimal merit and overcome defendant's defenses, including Civil Code Section 47D and 47B, which do not immunize a former attorney's extrajudicial media campaign that trades on the prior representation and misrepresents the record. Even where a pleading includes allegations referencing protected activity, which plaintiff disputes is the case here, the court may strike only the specific allegations or portions that supply liability based on protected activity, not entire causes of action whose gravamen is non-protected misconduct. Okay, so the arguments now. Defendants failed to carry their burden as to all of plaintiff's causes of action. Breach of contract, breach of fiduciary duty, and legal malpractice do not arise from protected free speech activity. In this case, the wrong complained of is defendant's breach of professional obligations owed to a client. The first, second, and third causes of action arise from defendant's professional obligations to Travis. Competence, loyalty, confidentiality, and adherence to contractual promises in the engagement. Defendant's conduct, as alleged, implicates violations of California rules of professional conduct. 1.1, which is competence, 1.3, which is diligence, 1.4, which is communication, 1.5, which is fees, 1.6, confidentiality, and 1.9, duties to former clients and complex, as well as Business and Professions Code Section 6104 and Evidence Code Section 953. Plaintiff further alleges defendants violated Rule 1.16E1 by failing to promptly release all client materials and property upon request. These professional duties exist, independent of any later media statements. The media statements are evidence of the breach and result in harm, but not the basis for liability. The public statements triggered plaintiff to undertake his own investigation of Travis's legal representation by defendants. As the California Supreme Court has consistently explained, the discovery rule applies to breaches of an attorney's fiduciary duty. When an attorney raises the statute of limitations to occlude a client's action before that client has had a reasonable opportunity to bring suit, the resulting ban of the action not only starkly works an injustice upon the client, but partially impugns the very integrity of the legal profession. A client's action against his or her attorney, whether pleaded as a malpractice claim, a breach of fiduciary duty claim, or any other theory of recovery, is not subject to the anti-SLAPP statute merely because some of the allegations refer to the attorney's actions in court. Therefore, at most, only discrete media statement allegations could be targeted. The core claims remain. Even if, arguendo, this court finds isolated allegations about press comments implicate protected activity, Civil Code of Practice Section 425.16 does not authorize striking the entire contract. Fiduciary malpractice claims when the gravamen is breach of duty. The proper approach would be to strike only the discrete allegations that supply liability, if any. At page 6 of the motion, defendants attempt to mislead the court by citing Freedman, reorganizing court, with the out-of-context blanket statement that the anti-SLAPP statute applies to claims arising from statements by a client's former attorney that allegedly harmed the former client. However, in the decision, the Second District Court of Appeal held that a statement is in connection with an issue under consideration by a court in a judicial proceeding within the meaning of Clause 2 of Section 425.16, Subdivision E, if it relates to a substantive issue in the proceeding and is directed to a person having some interest in the proceeding. In the declaration filed in support of the motion, defendant Freedman asserts that the Lively Baldoni litigation is an entirely separate matter from the copyright action. If the matters are separate, and they are, Freedman's extrajudicial statements about the copyright action cannot relate to a substantive issue under consideration in the Lively Baldoni proceeding, nor were the challenge statements directed to a person having some interest in the proceeding, as required by the Fremont and Neville cases cited by the defendants. Instead, the Freedman comments were disseminated to the press and the public at large, not to the court, counsel, parties, witnesses, or other participants with a litigation interest. Therefore, defendants cannot satisfy Section 425.16, Subdivision E2, in connection with requirement on these facts, and the court should reject defendants' attempt to characterize Freedman's media campaign, it was one statement, as protected petitioning activity. Good God. Similarly, Contreras, discussed in the motion at page 6, is also factually inapposite. Contreras involved a claim brought by a party against opposing counsel within the same underlying proceeding. That materially different situation is not present here, where plaintiff's complaint is directed at Travis's own attorney, and Contreras therefore provides little to no guidance on the issues before this court. Likewise, defendants' reliance on Bergstein, also at page 6, is misplaced. In this decision, the court found that almost all of the specific acts of alleged wrongdoing in the complaint are litigation activities. This action is different. It does not challenge Freedman's statements in his pleadings or other litigation activities undertaken in defending Justin Baldoni against Blake Lively. Instead, it arises, among other things, from Freedman's alleged breaches of his professional duties to a client and public comments to the media about Travis's case. Defendants' reliance on Peregrine Funding and Ross cases addressing allegedly non-communicative litigation conduct is an apposite. This action does not turn on protected litigation conduct of that kind, contrary to defendants' assertions at pages 2 and 9 and 10 that because Travis has passed, defendants may do and say whatever they wish Defendants may do and say whatever they wish. The attorney-client privileges survive. Defendants' reliance on Fox Searchlight pictures is likewise misplaced. There, the court held that only an in-house counsel could disclose ostensible employer-client confidences to her own attorneys to the extent relevant to the preparation and prosecution of her wrongful termination action against her former employer-client. These facts bear no resemblance to the professional misconduct alleged in plaintiff's complaint and do not support defendants' asserted privilege or anti-SLAPP theories. Okay. Litigating in the press is not automatically privileged petitioning activity. Defendant Freedman's statements in the US Weekly article and other media outlets are not protected by either Civil Code Section 47B or Subsection D. They were not made in the course of any judicial proceeding, nor in furtherance of one, and they do not qualify as a fair and true report of any judicial proceeding. The statements were made in breach of counsel's fiduciary obligations and therefore fall outside any claimed statutory privilege. For instance, defendant's motion selectively quotes Freedman by omitting the opening portion of his statement in the US Weekly article, which begins, "In the copyright infringement case, I learned what great people Justin and Wayfarer were." By making this statement, Freedman does not speak as Justin Baldoni's attorney, but as Travis's attorney, because it directly relates to the time representing Travis in the copyright action. I feel like that is nitpicky. And I think that's just a nitpicky way of looking at the wording. Ugh. This is a case of leveraging prior representation to benefit a new client, which results in a breach of the attorney-client's fiduciary duty to Freedman's former client, Travis. Indeed, the discussion by Travis's attorney is calculated to gain additional weight because the public is led to believe that Travis's lawyer must know something that they do not. To be clear, and Freedman did say this in his motion to strike, during the time of when he was representing Travis Flores in a lawsuit against Justin Baldoni and Wayfarer, he never actually met Justin Baldoni or Wayfarer. He never spoke to them. So, and this is why I'm thinking, this guy is just looking too deeply into this, because there wasn't any of that there. It's just the evidence, when they filed motions to dismiss and the evidence actually came forward, Travis Flores himself had to concede that there's no way that, that 5 Feet Apart was already well into production. It was already well underway to, becoming a film. before Travis Flores sent his script for 3 feet distance to, I think it was Caleb Remington, one of the other defendants, who was a consultant on 5 feet apart. And this guy is also overlooking the fact that 5 feet apart was actually written based on the kind of like on the story of another person with cystic fibrosis, Claire Wineland. Caleb Remington was a consultant because he also has cystic fibrosis. So I just think, when you nitpicking on things like that, like, saying, well, you didn't quote this part of the statement, which says, in the copyright infringement, you just said, I learned what great people just. It's like, really? Really? You're bringing a lawsuit for that? Okay. Indeed, the discussion by Travis's attorney is calculated to gain additional weight because the public is led to believe that Travis's lawyer must know something that they do not. This core principle of the attorney-client relationship was upheld by the United States Supreme Court in Swidler and Berlin. Knowing that communications will remain confidential even after death encourages the client to communicate fully and frankly with counsel. While the fear of disclosure and the consequent withholding of information from counsel may be reduced if disclosure is limited to posthumous disclosure in a criminal context, it seems unreasonable to assume that it vanishes altogether. Clients may be concerned about reputation, civil liability, or possible harm to friends or family. Posthumous disclosure of such communications may be feared as disclosure during the client's lifetime. Okay. Plaintiff can show a probability of prevailing on his causes of action. This should be interesting. The analysis of defendant's anti-SLAPP motion could stop here without reaching prong 2 because the argument fails. Regardless, plaintiff meets the minimal merit burden for the first, second, and third causes of action. Here, defendants allege misconduct, including concealment, conflicted conduct, and post-representation misuse of the prior attorney-client relationship prevented plaintiff and the estate from reasonably discovering the full scope of defendants' breaches. Accordingly, defendants cannot invoke the statute of limitations as a shield for their own misconduct, and timeliness poses no bar to plaintiff's claims. This is a contract and fiduciary duty case. It does not attempt to censor defendant's general speech. Plaintiff neither dispute defendant's right to represent Baldoni nor to speak in Baldoni's defense. Plaintiff challenges defendant's misuse of their former role as Travis's attorneys to publicly validate Travis's adversary's character and purported non-liability while discussing the copyright action. This is inconsistent with the duties owed to a former client and the estate that now stands in Travis's shoes. As the court may now see, Travis's copyright action was meritorious. Even at this early stage of pleading, the notion that one person wrote a story entitled 3 Feet Distance, while another wrote a story 5 feet apart on the same subject matter and plotline is ridiculous on its face. I mean, people can have similar ideas. I know we kind of experience the realities of having to distance, etc., during COVID. But for people with cystic fibrosis and other, serious illnesses where, your immune system may be, low, or you have a severe respiratory illnesses, and catching, viruses is a big deal. This is a reality. This has been a reality for them, all of their life, pretty much. And it is not implausible to have an idea about that, around a similar time as someone else having the same idea. I know that, like, during COVID, it was actually a nightmare for us, although we were kind of relieved when they brought in social distancing, because my little girl, I've spoken a lot about my little girl, and people are aware that she's got significant health problems. She had surgery in January. She relies on nasogastric tube feeding and can't control her blood sugar levels, but she was also born with a deficient immune system. So her three major immunoglobulins, the IgM, IgA, and IgG, are all low, and she can't fight illnesses. It's a nightmare when chickenpox is going around the school, because she's had it. She had to go into hospital and have intravenous acyclovir to treat just something simple like chickenpox. But also, she does not build up the immunity to never get it again, like most children do. Most children, if they have, once they've been exposed to chickenpox, that's it. They normally don't get it again. It might show up later in adulthood as shingles, but generally they don't go through chickenpox and again, and usually their experience of chickenpox is a really mild, bit of a virus. My little one, was hospitalized, and she hasn't even got the immunity of never getting it again. So I think this is part of the reason why this case is interesting, because my experience of my daughter's, it's called panhypogammaglobulinemia. I lived in Wales for 20 years, and that is still one of the longest words I had to learn. I've mastered it now, but this case is interesting because it does revolve around a severe life limiting illness. And it just makes me think of my little one, a lot. And that film, like it ends with us, was supposed to raise awareness of an incredibly important subject, domestic violence. 5 Feet Apart was supposed to do the same for for cystic fibrosis. And it is such a shame that it is being kind of pulled apart in, not just one now, but now 2 lawsuits. And it really does, it upsets me to see this, but I hope that when I'm covering it, I'm kind of trying to do it some justice. I mean, I'm not diminishing Clemenziori's concerns. I'm not saying that he has no concerns or he's been opportunistic. I don't. But I don't think that. I think he's assuming something awful of Brian Freedman. I just don't think is there. Had Freedman shared things like text messages between him and Travis Flores or something like that, then yeah, I could see the confidentiality breach. But to sit and say, well, that Justin Baldoni was, the case was dismissed against him and there was no finding of liability, is not breaching confidentiality. Let's keep going. Okay. Other sources confirm in sworn testimony that Justin Baldoni is not exceedingly honourable and highly ethical, but instead preys on the vulnerable and pirated their stories and ideas while passing them as his own. Finally, defendants mischaracterize the record when they assert that Freedman's statements to the media furthered the discourse about his representation of Baldoni in the Lively-Baldoni litigation, while defending Baldoni's character, reputation, and credibility in the Lively and Baldoni litigation. Okay. Freedman's public remarks went well beyond the narrow framing defendants now present to the court. Freedman did not merely comment on issues arising in the Lively-Baldoni litigation. He affirmatively praised Baldoni and Wayfarer, based on his purported experience representing Travis in the copyright action, stating, "In the copyright infringement case, I learned what great people Justin and Wayfarer were at a time when he was representing Travis Flores." Defendant's press narrative goes beyond fair report and is contradicted by the client's stated reason for dismissal. California Civil Code Section 47B defines privileged publication as one made in any 1. Legislative proceeding, 2. Judicial proceeding, 3. In any other official proceeding authorized by law, or 4. In the initiation or course of any other proceeding authorized by law and reviewable pursuant to Chapter 2, commencing with Section 1084 of Title I of Part 3 of the Code of Civil Procedure. While California Civil Code Section 47D includes privileged communication as one made, 1. By a fair and true report, or in or a communication to a public journal of A judicial, B legislative, or C other public official proceeding, or D of anything said in the course thereof, or E of a verified charge or complaint made by any person to a public official upon which complaint a warrant has been issued. California Civil Code Section 47D continues with an exception. 2. Paragraph 1 does not make privilege any communication to a public journal that does any of the following. A. Violates Rule 3.6 of the State Bar Rules of Professional Conduct. B. Breaches a court order. C. Violates a requirement of confidentiality imposed by law. Even if Civil Code Section 47D protects fair and true reporting of proceedings, defendant's quote is not a report of what the court did. It is a conclusory absolution. He's referring to the word in there, did absolutely nothing wrong. And a character endorsement. And he cites exceedingly honorable and highly ethical. Those are not the gist of a dismissal without admission of liability. They are new assertions deployed for public consumption. I can kind of see where he's coming from a little bit there. I can see it a little bit. Fair and true, in the context of the fair report privilege, refers to the accuracy of the challenge statements with respect to what occurred in the judicial proceedings. Such accuracy is measured by the natural and probable effect the statements would have on the average person reading, viewing, or listening to the report. The settlement agreement and mutual release of claims entered into by the parties in the copyright action is attached hereto as Exhibit B and provides in relevant part, the parties acknowledge that this agreement shall not in any way be construed as an admission by any of their parties as to the merit or lack of merit of the allegations in the action. The parties entered into this agreement to avoid the expense and uncertainty of litigation. In light of this expressed non-admission and the stated purpose of his client Travis's settlement agreement, Freedman's statements cannot reasonably be characterized as fair and true. Rather, they are at best incomplete and misleading and appear calculated to advance Justin Baldoni's interests and discredit the merits of the copyright action that Freedman filed. As the court can now see, the copyright action was meritorious, and defendants did a poor job representing their seriously ill client. And a lot of this is in the declarations from Melissa Yeager and Clement Suri, which I will do in the next video, because this is probably going to go over an hour. Yeah, I will. No discovery was undertaken by defendants and no merits adjudication support a sweeping exoneration narrative. Defendants' press statement in the US Weekly article and the media at large go far beyond reporting a procedural result. Did absolutely nothing wrong is not a fair report of a dismissal by stipulation, it is an advocacy certification. Freedman's statements went beyond merely reporting on the outcome of the copyright action. Freedman offered his personal legal opinion about the merits of his former client's claims and praised the character of his former client's adversary in the course of that other action, with the validating seal of his privileged relationship with Travis as his attorney. The copyright action ended without depositions or a merits finding. Such sweeping exoneration was unjustified and was certainly not fair to Travis. In 2022, Freedman's statement to the press that Travis dismissed the copyright action because his health is more important than the stress brought on by fighting this is inconsistent with defendant's own explanation for the dismissal in the US Weekly article. The email states, an email. The email states, "This is my client's statement. 3 feet distance. My script and story was a passion project of nearly a decade. It was based on real friendships and an important time within the cystic fibrosis community. The year the distance rule was first established. Mackenzie, Kevin, Jacob, Nicole, April, Amber, Tina, all friends with cystic fibrosis who have either passed or continue to battle, that my screenplay paid tribute to. There were so many similarities beginning with the titles, but also between the characters, scene, and flow of story that I felt I needed to stand up for myself and other artists from my community who also struggled to tell their own stories in this business. I ultimately dismissed the case because my health is far more important than the stress brought on by fighting this. I hope that someday there is room for my voice as a storyteller to be heard, as well as others from my community. There is no need to hire someone that is able-bodied and not from our community to create, write, and romanticize our struggles. We are here, willing, and ready to tell our own stories." And that was an email by Brian Freedman. So yeah, I am seeing Clement Suri's perspective here. I can see what he's fighting for. That contemporaneous statement is inconsistent with defendant's current public narrative that dismissal equates to factual vindication. Justin Baldoni's character is also far from being extremely honourable, as Mr. Freedman mentioned. Had Mr. Freedman conducted any discovery at all or investigated the facts before filing suit as required by Federal Rules of Civil Procedure Rule 11 in the copyright action, he would have discovered from Melissa Yeager, Claire Wineland's mother, right, so that's who that is, that her daughter has been used by Baldoni. This testimony undermines the factual fair report premise defendants rely on to justify their public absolution statement and heightens the impropriety of defendants presenting themselves as authoritative validators of independent creation in the media. Federal Rule of Civil Procedure Rule 11 required that counsel file pleadings in good faith after a reasonable inquiry under the circumstances, and it prohibits using a pleading position that is artificially deflated or otherwise not grounded in an adequate investigation and evidentiary support. As the court is aware, a party may not rely on a pleading posture that is not in good faith and in violation. Okay. Freedman was aware and had access to Melissa Yeager's information. In a June 17, 2021 email, Travis provided to Freedman a privileged document entitled Litigation Analysis. In this litigation analysis document at page 2, Travis provided the substance of his conversation with Melissa Yeager. Defendants never contacted Melissa Yeager to know more about Claire Wineland's role beyond the representations of Justin Baldoni and other defendants in the copyright action. The absence of any invoice, call notes from the attorney-client file that defendants returned to plaintiff constitutes in and of itself a violation of California Rule of Professional Conduct 1.16E1. Instead, defendants relied solely on a threatening letter from opposing counsel in the copyright action and quickly retreated with no investigation, research into the merits of the claims, and even without filing an opposition to the Rule 12b6 motion to dismiss, thereby breaching their duty to competently investigate and litigate on behalf of their client. Fiduciary duty and confidentiality survive death. The estate holds privilege and controls waiver of this privilege. The complaint states that the attorney-client confidentiality survives death in federal cases, such as the one Freedman was hired to prosecute for by Travis. California Evidence Code, Section 953, places privilege control with the holder. Here, Travis, and now the estate, is the holder via its administrator. The key point for this opposition is not semantic. Defendants cannot claim free speech privilege doctrines as a blanket shield. If any aspect of defendant's press narrative is privilege, it is not defendant's privilege to exploit. It belongs to the client, Travis, and now the estate, to protect or to waive. Defendant's privilege defenses do not defeat minimal merit as to the breach duties claims. Defendant's theory treats press commentary as automatically within litigation privilege and thus automatically protected. Courts expressly caution otherwise. Litigating in the press is generally not within the litigation privilege. The litigation privilege promotes the effectiveness of judicial proceedings by encouraging open channels of communication and the presentation of evidence in judicial proceedings. However, republications to non-participants in the action are generally not privileged under the litigation privilege and are thus actionable unless privileged on some other basis. Litigation privilege, as established in Civil Code Section 47B, does not categorically immunize attorney press statements. Defendants argue litigation privilege bars liability, but courts recognize that attorney press statements about litigation are generally not within the litigation privilege. At a minimum, plaintiff has shown this court sufficient merit to proceed on contract fiduciary malpractice theories that do not depend on defamation elements. Okay. Besides having to claim the attorney-client privilege on a client's behalf, an attorney must maintain the confidential information of present and former clients. Business and Professions Code, Section 6068E1 bluntly states it is the duty of an attorney to maintain inviolate the confidence and at every peril to himself or herself to preserve the secrets of his or her client. These confidences may or may not be subject to the attorney-client privilege, but must nonetheless be maintained as confidential by the attorney so as not to cause the client or former client embarrassment or harm. Okay, now we're coming up to an hour and we're only about halfway through this filing. I'm going to stop this here as a part 1, I think, and then I'm going to continue it with the part 2 then for the rest of it. Yeah, I think I'm going to do that then just to make it easier for people. Okay, I'll be back with part 2.